All right. Thank you everyone for joining. We have our latest Orlando Tech Community tenX Talks. Today we have Taylor Pancake from Foley Lardner, which is a nationally recognized law firm. I actually saw you guys were recently recognized by, I think it was Time Magazine and Statista as one of the top law firms in the country in 2024. So one of the leading law firms and a big presence in Central Florida and a big presence with early stage companies. So I thought it'd be great to have Taylor join us and do this kind of business law boot camp for startups, kind of review some resources, best practices, things like that within that the early stage companies typically see. This is brought to you by Orlando Tech Community. So if you're not a member of OTC, obviously encourage you to look into membership, look into participating in the Central Florida technology ecosystem. And just quickly, I think it's next Thursday, we do have our holiday party. So if you're a part of OTC, you want more information on that, please feel free to reach out to me. So yeah, we got Taylor Pancake on. He's a partner and leads a lot of the Central Florida practice for Foley. I'll pass it to you, Taylor. Thank you very much for joining.
Yeah, thanks very much, Ken. Appreciate that overview. I'll give a couple slides about Foley, but appreciate the warm welcome there. The topic today, Business Law Bootcamp, sort of painfully broad. So the intent here, we'll try to get through a couple of key discussions that we have in the early stage or the startup stage for most companies. Because it's a wide net and there are sort of a handful of people on the call, happy to take questions certainly at the end, but as we go through, if there are tangents from what we're talking about or really just anything related that you'd like to chat about, I think that'd be terrific. So happy to do that too. So real quick about Foley and Lardner. Foley is an AmLaw 50 firm, which means by revenue, we're one of the 50 biggest law firms in the country. That's not a terrific way to measure anything, but gives you some idea of just the size of the firm. Offices throughout Florida, which is a big concentration for us, and also throughout the country and the world, although our international offices are smaller than our U.S. footprint, which is really most of the practice. We really practice in all industries, so this isn't, we're certainly not going to go through this slide, but just give you an idea. It is a full service firm. The benefit of that is we tend to have an expert under the roof when niche issues come up, and they do from time to time for all businesses, which is great. This is our marketing slide. I think the one thing we usually talk about, sometimes there's a view that law firms are probably like accounting firms, that you need to wait and have it kind of right-sized. That's typically not our, Foley and other firms like us typically don't practice like that. We do a lot of startup work. We do a lot of work for really big companies. So really the entire gamut, and we have relationships all along the way. So today the agenda and again, there's a lot of content we could cover. This is not all day, so we're going to limit it a little bit. Talk about first entity selection. So assuming you've got an idea but haven't formed the company, what are some of the considerations about entity selection? Where and what, we'll get into that. Term sheets, we'll talk specifically about term sheets related to fundraising, but really some of that conversation about LOIs and term sheets will be general and cover other things you might do with those types of documents and discussions. We'll go through a couple of the early stage capital raising, sort of just common types of early stage capital raising. There's a lot of variety there, obviously, but it might be helpful to talk about it. And then our last thing will be a little bit of an advertisement, I guess, but this is a free resource, Foley Ignite, that Foley is very proud of. It's available. It's a national platform, but has a lot of resources for startups and early stage companies that are available for free. Some of it's thought work, think pieces, but also document generators for NDAs and other early stage documents. So we'll talk just a little bit about that. But that, you know, if you log off early, Google Foley Ignite, great resource, some really good stuff there. And again, all for free. So good resource. Not totally altruistic. We want to start relationships with innovative companies early on, and hopefully that's one way to do it. But we put a lot of effort into that. It's really good stuff, and the document generators are really user friendly. So we'll cover that again. So first, just on entity selection. So you've got an idea, you're starting a business, even if you've done it a million times. This is a common discussion and decision point. The first discussion tends to be where. So are we we're having this discussion in Florida. Is this going to be a Florida entity or a Delaware entity? Probably the most important is factor to take into account are your investor expectations. And everyone's investors are different, and they're human decision makers and have different preferences and expectations. Sometimes you don't know who your investors will be, and so you're sort of planning for. Actually, often you don't know who your investors will be, and so you're sort of planning for the unexpected or the unknown. In general, Delaware is viewed as the gold standard for jurisdictions, and so you will never get in general points off for forming your corporation or your LLC in Delaware. That'll look normal. Investors will understand it. Sometimes there's a preference though to keep it in the home state or for one reason or another to keep it as a Florida entity, which makes sense too. Sometimes that just comes down to number of filings, so complexity. If you end up having a single entity, this is probably overstated. One filing in Delaware and one qualification to do business in Florida, if that's where your initial activities will be, is not too onerous. For a lot of tech startup companies, though, that segregate operations from equity ownership, from IP ownership, you might have an org chart that ends up including quite a few entities, and so administrative cost just sort of adds up a little bit here. So that's one thing to think about. If you will be a regulated company, and this is something to talk with advisors, mentors, others that have kind of been regulated in the past in the jurisdiction that you'll be regulated in before. Some regulated companies that are going to be regulated by a particular state, Florida or other states, there is a preference for homegrown entities, or maybe the homegrown entity gets some benefit of the doubt in some of the early registration process. So occasionally that's a factor that we think about. And then just where will you do business? If the investors and the idea are in Florida, but this will really be a national business, sometimes the complexity will already be there. You're going to have these national filings anyway. You might want to skip right to the national choice, Delaware, New York, et cetera. And then the last one, which is surprisingly not talked about too much, but it's a big deal, privacy. So there's a feeling, and it's maybe ironic, that Delaware's the gold standard. It's the best way to do things, and that's true. Delaware's also a very low information state in terms of the publicly available information about most companies. So you can sort of have the best of the both worlds sometimes if you like the shield of less information out there to the general public. Sunbiz, if anybody's kicked around with the Florida Secretary of State's website, we have a very high information state. So there's a lot of information about the managers, the directors, the officers of a business. Now it's self-reported, so sometimes it's not of the highest quality or the most updated, but there's a lot of data on the Secretary of State's website when you register in Florida. So sometimes that's a factor. As a quick footnote, there's something that you've probably heard about already. If not, we'll all be talking lots about it in the coming years. There's a new federal Corporate Transparency Act that's administered by FinCEN for brand new companies. That starts January 1st, 2024. So just around the corner. If you organize a new entity, you have a report to FinCEN federal office to tell them about the key equity owners of that company. Now, that's not publicly available information, but sometimes it's part of the same conversation about privacy. For existing companies, good news, you don't have to worry about that until 2025, but that's something that is new to all checklists and people will be talking about going forward.
Hey, Taylor, question on this. What investor types don't prefer a Delaware C Corp? And is a Delaware C Corp just kind of the standard optimal way as far as like flexibility and appeal to the most investor types?
Yeah, probably, right? So I think that it's certainly the most. You're going to, the average, and it's probably in the high 75% range is that folks are going to expect certainly a Delaware entity, and we'll talk about LLC versus corporation in a second. So if you just want to go by the averages, that's certainly you're going to offend no one. You're going to look good. That's not going to be viewed as a strange decision. Sometimes you'll have an early investor that maybe their counsel is Florida only, although most transactional attorneys are sort of equally comfortable with Delaware and their home jurisdiction. Or maybe there's just a preference for some reason for it to be from your investor for it to be a Florida entity. That's I don't want to say unusual, but that's certainly there are less instances of that than just the expectation that eventually we'll want to be a Delaware company, and so let's just start out with that. So the second question is corporation or limited liability company. Now there are some other entity types here. We're sort of generally distilling this down to corporations or LLCs. The vast majority of tech startups are corporations because some of the things we'll talk about in a second matter less or are just worth it within those structures. But this is not necessarily a given, and it's worth talking with your attorneys and your accountants just to make sure that whatever you see in your crystal ball for the company, the entity selection makes sense. The first one, taxes. I had a mentor that told me from an attorney perspective, if you don't understand why a decision was made, it's always taxes. That's kind of generally true. Here's another example of that. In general, and there are certainly exceptions everywhere, but the corporate form has a double tax. So profits are taxed at the corporation level. Corporation is its own taxpayer. And then again, when a dividend is paid or a distribution is made, there's tax to the individual equity holder that gets that dividend or distribution. So there are two layers of taxation versus an LLC that's elected to be treated as a partnership. There's a single level of taxation. The LLC itself is not a taxpayer. The individual equity owners are taxpayers, and so there's tax only on the distribution made to the equity holders. Now there are caveats there. There's kind of broad generalities, but that's usually the calculus that's done to decide, or one of the big factors to decide which entity makes sense for your business. There's an investor expectations component here. Most investors, and this is probably, again, the same percentages that would prefer Delaware C Corp will probably prefer to invest in a C Corp versus an LLC. There are some investors that won't invest in an LLC. And so the nice thing about the LLC is the single tax. The scary thing to some investors is that you can have phantom income in an LLC. The tax is paid based on profit that's allocated, but the LLC gets to decide whether a distribution is made. So sometimes you can have an allocation of profit as an owner of the LLC, an equity owner of the LLC, but get no cash to pay the tax bill. So that can be a little bit frightening for some investors that they don't have control over that. And so often there's a strong preference for the corporate form. And then the next thing that we think about is there's double tax for an LLC. Is the response to that, so what? The anticipated company trajectory matters a lot. If you're going to make, if the plan, like a lot of tech startups, is that we're going to have years and years while we develop our business and technology, and we're really making no profit. We're not yet, either everything's going right back into the business, or the revenue is going to follow the development of the business and the technology. So there's technically double tax, but we won't have any profit to be subject to that double tax. So it doesn't matter. So if we're going to have a hockey stick trajectory where it's flat for a long time and then spikes up when we're getting ready for exit or the next stage, that's fine. Not every business is like that. And I think one thing that's often lost on general discussions like this is we're talking about tech startups that have that kind of common path, and we leave out the fact that there are lots of other startups that are going to be solid cash flowing operating businesses for years and years, and the plan isn't necessarily to go through that common storyline. So if the business is likely to have lots of revenue for years and years before it gets to the next exit event, whether that's sale of the company or significant IPO or other significant investment, it might be worth it to talk about the LLC as a preferred form of business, because the single tax layer might matter if you're going to have years and years where there are profits that are distributed to the equity owners. And then the final is a little bit more blocking and tackling. For C Corps, there are, especially in the startup stage, there are lots of resources that give you lots of standard documents. There are a lot of things that can work well enough off the shelf. You can certainly customize, but you don't always have to in this space. There are document generators, and there are lots of resources, whether it's the NVCA or other organizations that support startups, that give form documents with lots of annotations, and it's all there off the shelf. The statutes tend to work a little bit more in a default standard for corporations versus LLCs in Delaware and Florida and most jurisdictions as well. So you can the corporations are a little bit less customized by default, and can be a little bit easier to work with for that reason. The wonderful and terrible thing about LLCs is they sort of allow for unlimited customization. So you can have lots of variety. If you've got creative investors or want to do things that customization really gives a lot of benefit, it's terrific. You can sort of accidentally get pretty complicated too, certainly over time, and so that's something we want to be careful about. But the LLC form does allow for lots of customization. The biggest question we tend to get is which is better for liability protection, and maybe the good news there is they're about the same. That there's really not much difference in terms of your exposure as an individual investor in an LLC or a corporation in terms of how much liability you might have through your investment in the business. So it's good news, but not very helpful on the decision. So next we'll kind of get into term sheets, LOIs, MOUs. You'll hear lots of these terms thrown around. There's one question that we always lead with, was when we hear, hey, we got to get a term sheet together. What do you mean, right? So there are a lot of different starting steps really depends on what we're trying to tackle. And there's an eye of the beholder element here, where sometimes sophisticated people that have done this lots of different times say LOI and they mean what the other guy thinks of as a term sheet. So good to get clarity when you're tackling a project with a potential investor or potential business partner as to what exactly you're trying to accomplish. So term sheets tend to be, at least I think what most people think of, this is just the facts. The term sheet's not necessarily even a non-binding agreement that's signed by the parties. It tends to be the terms that everyone's agreeing to. May or may not have a signature just to kind of acknowledge that everyone signed off on it. But it is usually just the executive summary of what the parties are trying to agree upon. I mentioned the NVCA earlier, National Venture Capital Association. It's an excellent resource. That website, nvca.org, you can find a host of materials, but most helpful are all the NVCA templates. So if you're not familiar with the NVCA, they, as it sounds, represent venture capital investors and companies and others in the ecosystem. They recognized years and years ago that hey, when we're negotiating these early stage either Series A investments or other things like it, we're spending a lot of time having one side say, here's what we want from a documents perspective, the other side giving lots of comments that chews up a lot of resources in terms of just legal spend. How about we collectively as a group get together and start out with some middle of the road documents that everybody can agree. This is where you should probably end up. There's variety on every deal. Every investor and company has different sensitivities, but if you start with these forms, no one has to go through the process of drafting from scratch, arguing about what market is, and that should be more efficient. I think it's been really helpful. They're updated from time to time. They just went through a pretty extensive update in 2022, so pretty fresh. And best of all, the templates are there with lots of annotations. So some of it's pretty dense, but if you want to just dive into for example, the Series A term sheet is excellent. Goes through with maybe 68 footnotes, things that you will have to potentially think about and decide upon with your Series A investors. Now that's a little further down the road than pure startup, but really good resource. A letter of intent tends to be coupled with a term sheet and usually is non-binding, but gives an agreement that both sides execute. It discusses the deal, the purpose, attaches the term sheet, and might include some more binding provisions. We'll talk about strategy and binding or non-binding in just a second. And the other one you'll hear used interchangeably with LOI and term sheet is MOU, Memorandum of Understanding. Sometimes these are synonyms, but often an MOU is something a little bit different. It might be really intended to be essentially a temporary agreement. We're not agreeing to work toward an agreement. We're agreeing on something right now, with the understanding that we're going to, this is a 2-page memorandum of understanding. We haven't covered all of the blocking and tackling, but this is good enough to get started, and we'll put a fulsome agreement in place at some point in time in the future. Again, there's a ton of variety here. Eye of the beholder. You'll see some things called one thing and look like another, or different experiences. So key strategic terms when we're talking about a term sheet or an LOI. First, is it legally binding? Usually the working thesis is that these are not legally binding apart from a couple of key provisions. So we'll talk about those here: exclusivity, confidentiality. Those tend to be binding. There are a couple of things that you live with when you sign the LOI or the term sheet. Otherwise, it's not binding. So the thought is, as diligence is done or more discussions are having, the deal might change. but not so fast, right? The big strategic issue is that you will hear people yell, "That's not in the term sheet," or "We agreed upon this in the term sheet plenty." So don't take too much comfort in the idea that these exercises are non-binding. People still remember what's in it, and so from a psychological or relationship perspective, you really have to mean it. This is usually not the start of a conversation on key terms. It's where we agree upon key terms, and so even though it's non-binding, it's difficult from a relationship capital perspective to change from some of the core terms. You can't get sued, for walking away. In general, you don't have to close on with the deals with the terms that are included in the term sheet, but it's going to be really difficult to change key terms without being accused of retrading or having some some negative impact on the relationship with the folks on the other side of the table. So if it is not a binding term sheet, typically a few terms might be legally binding, notwithstanding the treatment of the rest of it. So exclusivity, do the investors have essentially a period of time where you have to negotiate with them and no one else? That type of provision would typically be binding, and there's lots of variety on how that works. But that's something that investors or whoever's on the other side of the table, if it's not a capital transaction, would generally want. Sometimes there's a breakup fee. This is uncommon in early stage financing, but becomes more common in later term M&A or more significant financing, where there might be a fee if the company walks away. On certain terms, there might be a fee if the counterparty walks away. Although that's less common. And then confidentiality is pretty common. So investors that want to keep things simple will often have a confidentiality provision, and sometimes say, "Hey, confidentiality is covered by the binding provisions of the term sheet. So start sending us diligence and populating a data room that we've given you a link for." The one thing to keep in mind is that the term sheet is generally not a non-disclosure agreement. So it gives you, if there's confidentiality, should give you some cover to share some things. You would typically want a more robust agreement in place when you're really getting into more fulsome diligence. And not that page count matters ultimately at the end of the day, but a typical confidentiality provision in a term sheet might be a paragraph or two. A typical NDA just covers more issues and more contingencies, is probably a 3 to 6 page document. So you want the better protection if you're really going to get into sharing sensitive information and diligence. And then the stalking horse, can you shop it? So the big question that often comes up is, "Hey, this is great. We've got this term sheet from an investor. There is or there isn't exclusivity. Can we use that to have conversations with other investors?" And most investors obviously don't want that. They don't want to be a stalking horse that gives the market some idea of a good starting point for discussions. They want exclusivity. They want the term sheet to be subject to confidentiality itself. So not just the information you might share, but the terms in the term sheet might be subject to confidentiality as well. On the investor side, that's a point of sensitivity. They don't want to be just the first offer that's used to get a better offer. They want to be at the table exclusively. So kind of getting into that a little bit, the strategic view from each side, the most important investor goal is to lock them up, get the company engaged in exclusive discussions so you can see if there's a deal to be had there and do your diligence. And by the way, get something in exchange for the resources you're devoting to that diligence. And usually that something is a period of time, that exclusivity where you're the only suitor that can transact or move forward, or at least you're the lead suitor for a group of investors that gets a chance to make something happen. The company goal is probably more general. So sometimes there's an impulse to, let's move as quickly as possible. Let's skip the term sheet. We all know what that's going to look like and get right into the key documents. That works occasionally, and sometimes it doesn't. Sometimes it's better to negotiate the hard terms now. If you've got a one-page term sheet with kind of bullet points and no one has to worry about technical or legal jargon, if you're just trying to figure out whether you can agree on those bullets, that's really useful to know whether there's a deal or there isn't a deal, or whether you're on track or you're off track. From just a technical perspective, it gets really inefficient and, by the way, expensive to negotiate in the final documents, because there's more blocking and tackling that goes into distilling the bullet points into final documents. So there's just more work to be done if the parties go back and forth or have discussions about what all of those terms should look like. In general, having a term sheet negotiated makes the deal move more smoothly. The business teams can focus on core business items, and then leave it to the attorneys and others to document the deal that the business teams have agreed upon. Doesn't always work that smoothly, by the way, but at least in theory, that's a great way to think about it, and take some of the business decision issues out of the drafting attorney's hands, which is positive. So I'm an attorney, but recognize that it's we tend to make things more complicated, not less complicated. So the more things we can move out of the decision making and drafting process of the attorneys, the better. And it's less costly to terminate the term sheet stage. Your team will spend less resources, costly in terms of legal spend, probably, certainly also less costly in terms of bandwidth from your team, which is obviously a big deal for any business. So I'm not going to go through all of these, but again, the NVCA term sheet's a great resource. I think it talks about probably all of these somewhere in the NVCA docs. I think the takeaway from this slide is the term sheet can cover a ton of ground, certainly when you get to the Series A, or it can be relatively simple. And so there, one strategic decision, or what are the things do we really care about? Do we want to rely on sort of market defaults for some of these things and punt to documenting the deal, or are there things, and probably the highlights are always valuation, obviously purchase price, sometimes voting rights, and board rights. Those are the real stars of these conversations typically. And then maybe depending on past trauma or plan for the company, some of these other things are important too. But a real good strategic conversation to have early on is, if you're on the company side, if you're in the investor side, what do we care about, and what do we want to really cover at the term sheet stage?
Yeah, just my quick interjection on this is that just from an investor point of view, it's, companies can get overly fixated on valuation very easily. And if, a company is extremely determined to get one valuation number and you let the investor negotiate the rest of the term sheet, it can be disastrous for you, right? It's, you kind of have to view the agreement in totality. And there are a lot of levers in economics, like liquidation preferences, dividends, anti-dilution, and then there's a bunch of other, basically everything else I'd throw into control. And you want to obviously maintain the right level of control for the company, and you also want the economics to reflect what you think the economics are. And if you get overly fixated on valuation, that can be detrimental in the long term.
Yeah, absolutely. And we try to, without making people too nervous, right? Keep in mind that your investors have gone through this conversation many times. A lot of times the startup team has gone through it less, and so they're potentially looking at angles that you're just not thinking about yet. So make sure you sort of trust your advisors.
Yeah, and even the long-term point I'd make on valuation is just that if you get like the higher isn't always the better, right? Maybe in the short term it is, but then when you see like the market pull back like it is right now, and you see a lot of companies going out and raising down rounds or having to reprice the options internally, that can be pretty, uh negative on morale throughout the company. So you do want to price to be able to maintain kind of that up and to the right trajectory that keeps everybody confident and excited rather than just getting overly fixated on what evaluation is in the next 3 months rather than the next 3 years.
Yeah. Yeah, and it, strategy is tough, right? It also puts emphasis on fundraising is hard, but sometimes you don't want to over fundraise either, because if you're having an early round and it's really trying to get as many dollars in as possible, it can really amplify the difficulty of dealing with that early valuation issue that Ken was just talking about. And down rounds are sometimes inevitable if you did really well or maybe had certainly kind of a seed fund investor that didn't mind as much what valuation was chosen. That won't always hold up, and like Ken said, it does have impact on morale. Can really, especially folks that have gotten equity awards along the way and are impacted by the down round. It's not nothing. Um, so we'll talk about some of the common early stage capital raising. So what we see a lot of in early stage convertible notes, we'll talk about all these SAFEs, Series Seed rounds or friends and family rounds, and then the Series A preferred, which is what we kind of hope to get to, that, but is typically a little further down the road for most startups. So convertible notes, again, and this just at a high level, convertible note is a promissory note. So it's a debt instrument that allows at some point in time the debt to be converted into equity in the next round. And there's a question about what is the next round, but the next round of equity raised. The big attractive thing about convertible notes, they're relatively simple compared to an equity round. Investors don't have to understand, how the certificate of formation or the bylaws work. They just have a note. And the biggest benefit is you don't have to have a discussion about valuation at all. There's no, with some caveats here that we'll talk about, there's no discussion about what the company is currently worth. And that's the biggest challenge for most early stage companies. There's a disconnect between what the founders and the early investors know or believe the company will be worth when you start proving out more of the business thesis, and what investors are willing to recognize at the time the investment's coming in. So you might know you've got $1 billion idea. All you have to do is get through a little bit more execution. The investors might reasonably say, okay, we're on board, but you haven't done that yet. And so there might be a disconnect between, or just a difficult conversation if you were otherwise forced to do it, about, well, what's the company worth today? Convertible note lets you not worry about that for the time being. You're going to have kind of a placeholder where the cash comes in. It's treated like debt initially, and when there is that next round of equity, then the convertible note holder becomes a net equity investor through conversion of the note. Now, usually there are some benefit to doing that, right? So if you invest in 2023 in a convertible note, that cash was at risk for a while. If the next round of financing happens 6 months or a year down the road, so in theory, you should be rewarded for that as an investor. And so a lot of times there's a discount. So if there's $100,000 that's invested through a convertible note, maybe you get a 20% discount on the purchase price for the stock that's being purchased in the next equity financing round. That's pretty common. In general, the convertible note, the investor in the convertible note doesn't have a discussion about, or isn't part of the discussion about what the valuation for the next equity round is. They're trusting the investors that are negotiating that next equity round to make a reasonable decision there. The valuation cap sort of protects, is a common term that will protect the convertible note investors from an unexpected result in that discussion. So the valuation cap might say, okay, we'll convert at the next equity round at whatever valuation is decided upon that round, but no more than $5 million for the overall company. So even if the investors agree that the company is worth 10 million, the conversion of the convertible note would be based on that $5 million cap. So it's protective of the convertible note investor. And in combination, and that's something we'll talk about with safes, there's some variety. Sometimes you get both. The investor will insist on both discount and valuation cap. And that obviously, depending on what the facts end up being, can be a really sweet deal for the convertible note investors. Sometimes that causes some friction with your new equity investors. There's typically an interest rate. It's debt. And so that's on your books as a company. Sometimes it really kind of depends on industry and depends on investors. Sometimes it's not great even though it's convertible debt and everybody knows what that is for, is what you'll hear, plenty. It's still debt on the balance sheet. And so sometimes there's a slight negative that you're carrying debt on the balance sheet. It's debt. Other things to think about, a lot of times if you have a note round, so it's not a single investor that's putting cash in, you've got to deal with how are you going to have conversations with that group of investors in the future if you need to. And often you will need to. And so if you had a convertible note round where 7 folks put cash in the company through these convertible notes, and your investors in the next round say, hey, we need your convertible note holders to agree on a slight change to the discount or to the valuation cap because we care about what that means to the overall cap table. Do you have to have that conversation with each note holder, or is there a process in place that allows a majority of the note holders to agree to amendments? And obviously that's better, but doesn't happen automatically. Safes, simple agreement for future equity. So this is relatively recent, last 10 years or so. Innovation, Y Combinator and others kind of identified that, look, we all know what the convertible note's really supposed to be for. We don't really need these debt instruments, which are kind of half one thing, half another. What we really are trying to do is have an agreement that we're investing now and we get equity in the future. And so there's a product, a simple agreement for future equity that has been become more popular. In general, some of the thinking and writing about safes versus convertible note, the convention has been that for a safe investor, you tend to choose, do you want a valuation cap and no discount, or do you want a discount and no valuation cap? Now, there's no reason why you couldn't ask for both, other than really just market. The expectation is that if you're investing in safes, the investors tend to choose which of those protections they want, not both. The only other thing to kind of mention, like anything novel, these were really popular for a really long time. There are a lot of folks that really love safes and love the simplicity of them. In the last 12 months or so, there's been maybe a little bit of bloom off the rose when the Silicon Valley Bank collapse happened, and a lot of folks were having discussions about, gosh, we might see a lot of our investments in early stage companies hit some headwind a lot earlier than thought because of collapse and financing in the area. What do we got? What are our protections if we look at a lot of liquidations earlier than we thought, and realize that, hey, that's one reason that it's better to be a debt holder rather than a novel safe investor, because we're not really sure what a safe is if there's liquidation and you're talking about creditor preferences. And so you see some investors that were really kind of gung-ho on safes, again, for the simplicity and for the kind of customization that made it work really well in this space, that have kind of pulled back and gone back to convertible notes, maybe the kind of the old way of doing it. So a little bit boring, a little less novel, but maybe a little bit predictable. And again, maybe there's more certain case law about if you're a convertible note debt holder, what are you if there's a liquidation of the company. Series C to friends and family, a little bit like term sheets. There's a what are you talking about factor here. People will say we're doing a seed round, we're doing a friends and family round. They'll mean lots of different things here. So seed round just generally usually means a small, maybe less formal than Series A round. A lot of times this is a small amount of cash, and it comes from friends and family or sort of one or two friendly investors. It can be preferred or common. It's usually the Series C is more likely to be preferred, though not necessarily, and there's a lot of variety here. When people say it's preferred, the question is always, well, what does preferred mean? That can mean that there's a dividend attached to it. It can mean there's a priority claim on assets. It can mean all of those things. So preferred doesn't necessarily just mean one thing. There are some pretty good documents out there at seriesc.com, which was a crowdsourced project to come up with, like the NVCA, which focuses more on the Series A, a good set of documents for the Series C round. It's a great resource. I like those documents, and we've used them before. There's some good writing about it, but that's a project that really hasn't been recently updated. I think 2013 was the last time those templates were so it's a little bit less of a current resource than in NVCA docs, but a good certainly for strategic thinking and learning about the way other people have tackled some of those early stage investments. It's a great resource. It might not work quite as well as NVCA in terms of giving you a view of current market, but nonetheless. Because those friends and family rounds can really be, there's lots of variety. Could just be purchase of common stock, but sometimes there are key terms that are included. We deal with the aftermath of some of the investor agreements that happen in some of those early stage rounds, and particularly if it's a relatively small amount of cash, you sometimes have to deal with things that reverberate through later rounds, and sometimes that's board rights. Can be a little bit of a disconnect if it's difficult to reconfigure the board or remove somebody from the board that invested a small amount early on. Not always, and a big board isn't necessarily a bad thing, although there's some difficulties that can come along with big headcounts. But you want to be really thoughtful about who and for how long they get any right to be part of the board of directors or the board of managers if it's an LLC. And one thing that's real, most favored nation provisions, we've seen these end up in some of these early stage seed rounds. In theory, so most favored nation provision generally means, hey, I'm agreeing with you that if we agree within some period of time, by the way, sometimes we've seen this essentially on an unlimited basis, which is really difficult to deal with. But if we agree to a different deal within a year with another investor, we're going to give that deal to you too. And this is one of those things that tends to sound fair. Sounds like, okay, that's something that is reasonable, and because we're partners here, that's something that we should be able to agree to. In practice, it's pretty difficult to even know what it means, and certainly to administer. And so we want to be real careful about those. Have a big discussion about those. A lot of times, it's hard to figure out when, for example, someone has invested in an early stage common stock round, and there's a most favored nation provision that's been agreed upon in a side letter or otherwise. And then there's a convertible note round, or there's a preferred round. Does it apply? And it sounds like it should be a simple question, but it's not that simple, and can cause lots of problems. So want to be careful and thoughtful about those. Series A financings, won't get into too much detail here, but again, my pitch for the NVCA model docs give you a really good overview of what a typical Series A financing looks like. Ken, I don't know if you've seen much variety, but even after all these years, most Series A investments that we're involved with use the NVCA docs, and the big benefit is you'll literally get red lines from either the company side or the investor side saying, here are essentially the changes from the NVCA docs that we're proposing. Makes it a lot more streamlined to get to the closing table. So if you want to know when you get to Series A eventually, if it's a relatively new and start planning for that, it's a great resource just to look at the NVCA docs and go through some of that.
Yeah, and I would say that I think it's moved to the seed, like just that there's a lot, the institutional capital has moved earlier and earlier, right? So you see more more of that kind of language even at the seed stage, and that it might be like required in a term sheet, right? So you might say, we're going to be drafting docs using NVCA standard terms.
Yeah, and that's a good point. And even at the seed stage where you might not get the full suite of Series A documents, you will get this purchase agreement, et cetera, will pull directly from the NVCA Series A doc. So it's a terrific time saver for everybody. Helps just those fights about what market, take some of those off the table, which is good for everyone.
Hey, I know we only got a few minutes left. Just want to be mindful of time. So
Yeah.
I don't know if you have any kind of wrapping up thoughts, or if
No,
you
that's my
questions.
one other wrap up thought is just Foley Ignite, kind of a another pitch for that. We there's a startup document generator there that's really good, user friendly, NDAs, and lots of insights and resources. We update that frequently, and so there's a lot of good content available there. But otherwise, nothing else high level. Happy to, if there are questions or any discussion we'd like to have, happy to entertain that.
Okay, yeah, let's happy to open it up for questions, or pause here if anybody has anything.
Can you go back to that last screen?
Yeah, sure.
Thank you.
Yeah, and just kind of looking at through some of the chat, Eric asked, do you specialize and/or always recommend C Corp? Are there scenarios, for example, smaller businesses where we might recommend S Corp or partnership LLC? Yeah, absolutely. And we've had some tech startup clients, so it's not necessarily just smaller businesses that might choose an S Corp or a partnership LLC. We've had some tech startups where they realize, look, our crystal ball shows us that we're gonna grow this slowly with revenue sources over the next 7 years, and so we're not going to be in the red until we have an exit event. So there's going to be lots of revenue coming in. That's where that double taxation might really matter, and it might be worthwhile to look at an LLC, or S Corp is a corporate form that has the single layer of taxation. S Corps are great. There's some restrictions depending on who might own it and what you might do with it. You can only have a single class of stock. So we didn't talk about it just because it's not niche, but not as broadly helpful to everyone. But yeah, absolutely, there are lots of scenarios where an LLC or an S Corp might make more sense. totally text driven.
Awesome. All right, well, I know we're short on time. Looks like there's you know, I would encourage everybody to go to Foley Ignite to look through those resources. Taylor, is there a good way for anyone to reach out to you?
Yeah, sure. So my
Go.
contact information's there. Feel free to call my direct line anytime. Like a lot in the post-pandemic world, that's right to my cell. But it's meaningful to us at Foley. We like to pride ourselves on being, we say, bad business people. We love the startup community. We like to having lots of conversations. For us, it's not about how to turn every conversation into a paying client. A lot of my favorite relationships have come over kind of general questions and kicking things back and forth for years and years. Above all, I think that's a lot of fun. So I'm always happy to have conversations about anything that you guys are thinking about from a planning perspective, or want to hear how different teams have tackled things. But feel free to reach out anytime.
Awesome. All right, well, I appreciate it and appreciate everyone joining here. We'll share this on OTC channels. Thanks, Taylor.
Thanks very much, Ken.
All right, bye.